Welcome to U.S. Immigration TV. Well, on September 9, 2022, the Department of Homeland Security, or DHS, issued a final rule on the public charge ground of inadmissibility. The final rule will be effective as of December 23, 2022, and will apply to adjustment of status applications postmarked on or after that date. But who or what is a public charge? What government benefits could make a person inadmissible as a public charge? What government benefits may a non-citizen apply for and receive without being considered a public charge? Well, watch this video until the end for the answers. And of course, make sure to like, share, and subscribe to this channel. Well, by way of background, the concept of public charge has been enshrined in our immigration law for decades. The idea is that if a person wants to immigrate to the U.S., they should be self-sufficient, industrious, hardworking, and able to support themselves versus having to rely on U.S. taxpayers for their care and support. Well, if a person could not sufficiently demonstrate that they or a sponsor on an affidavit of support could provide for their basic care and necessities, well, then they could be considered inadmissible and their immigrant visa or adjustment of status could be denied. Well, in 1999, Legacy Immigration and Naturalization Service, remember the old INS, which is now the USCIS, issued guidance on what constitutes a public charge and how immigration officers should evaluate an applicant's likelihood of becoming a public charge. Well, that 1999 guidance has really been followed up until the Trump administration, which then issued new and really more strict guidelines as to what constituted a public charge, creating much anxiety and confusion because it appeared that the receipt of any kind of government benefit could result in a person being considered a public charge and therefore jeopardizing their ability to obtain a green card. I mean, I remember there was a lot of fear that elderly people, retired, maybe not be able to come here to work, and were they going to start denying or refusing their visas or green cards? Well, thankfully, the recently issued final rule on public charge basically goes back to and follows the old 1999 public charge guidance. So let's go through a couple of items. Who is a public charge? Well, a person who is likely at any time to become a public charge means that it is likely that the person at any time in the future will become primarily dependent on the government for subsistence, such as demonstrated by either, number one, the receipt of public cash assistance for income maintenance, or number two, long-term institutionalization at government expense. Well, what does primarily dependent mean? Well, it means, and I quote, significant reliance on the government for support, and means something more than dependence that is merely transient or supplementary. In other words, to be a public charge, a person would need to receive, let's say, welfare or cash and be hospitalized for a long time. What are the factors that are considered for public charge? Well, by law, immigration officers should consider the following factors in evaluating whether a person would be considered a public charge: age, health, family status, assets, resources, financial status, and education and skills. What government benefits may be considered under the final rule? Well, as previously noted, to be considered a public charge, the person must have received public cash assistance or been institutionalized at government expense. Public cash assistance for income maintenance includes only receipt of supplemental security income, or SSI, cash assistance for income maintenance under the Temporary Assistance for Needy Families, or TANF, and non-federal cash benefit programs for income maintenance received by the person from the state. Okay, what does long-term institutionalization at government expense mean? It means under Medicaid, but only if under the Social Security Act. It does not include short periods of stay or hospitalization for, let's say, rehabilitation purposes or home and community-based services like HCBS under Medicaid. And DHS also will not consider the receipt of the Supplemental Nutrition Assistance Program, or SNAP, or other nutrition programs or Medicaid other than for long-term time or hospitalization, housing benefits, or any benefits relating to vaccinations such as the COVID. What if family members receive public benefits? Well, benefits received by family or household members are not a public charge factor, even if the person themselves would be disqualified if they received the benefit directly, and even if the applicant applied for the benefit on behalf of that family member. Therefore, if a person, let's say, has a U.S. citizen parent or child receiving government assistance, this should not affect their own situation in relation to be considered a public charge. What do we have to conclude by this? This final rule, I think, is a welcome change or a return to the traditional public charge analysis. Now, if you are being petitioned and have received any kind of public or taxpayer assistance, and you have questions or concerns about being considered a public charge, I would strongly recommend that you consult with an attorney who can evaluate your situation and make sure that your case will not be denied based on your being considered a public charge. I hope you have found this video informative, and of course I will continue posting videos which I hope that you will find helpful and informative to you, your family, your friends, and your case. I'm Michael Gurfinkel, and don't forget to like, share, and subscribe to U.S. Immigration TV.